advocating support or opposition to legislative bills.
I just came out this morning because I oppose this because I believe it puts an undue burden on the grassroots organizations. The big national organizations that want to bring money in here to influence Oklahoma, they can manage all this, but when some of our neighbors try to get together, whatever the cause, you know, all of a sudden they hit the first threshold and then they get all this extra weight put on them, which limits their ability to let the legislature know how they feel as citizens. And that's all I have.
Thank you. Our next speaker, also a citizen, Mr. Bryce Smith.
Hello. It's good to see everyone again. I would just like to get some perspective of what we're talking about on the grassroots side of things. This is $500. This will not buy you a Tom Ford belt. This will not pay your Mercedes payment. It probably won't pay your rent. If you make $7.50 an hour in Oklahoma, you will have to spend 77 hours of your life to make $500 after taxes. So I think that when you look at the grand scale and the scheme of the political system, what is worth more? An endorsement tweet from Governor Stitt or President Trump, or $500 organized on behalf of grassroots organizers? Thank you.
Mr. Trent England.
Visual. You get a license for that?
Thank you, and I will be brief. Thank you, Chair Long, for being so thoughtful in your comments. And I am Trent England with the Oklahoma Council of Public Affairs. I am speaking not just for myself and for OCPA, but also for what is now 3,225 Oklahomans who have signed a petition because they don't want the potential for their name to show up on a government list that says Jane Doe believes in this cause and gave it money, and here's her home address, and here's who she works for. We've been told that this rule was very narrow and was not meant to capture the soccer moms that I talked about in December and mentioned again last time. Excuse me. We've been told that this is obviously constitutional and that it's about outside groups secretly trying to influence policy in Oklahoma. I received back, and I thank the Commission for this, my Public Records Act request earlier this week. And I do believe that some of what the public has been told about this rule is just not accurate. For one thing, as I mentioned at the last meeting, one group, one outside group, one group that doesn't disclose its donors, was intimately involved in crafting this rule through what appear to have been multiple conference calls and many emails and much collaboration going on behind the scenes, and that's the Brennan Center in Washington, D.C. Now, I agree with them on some things and disagree with them on other things, but it smacks of a little bit of a lack of self-awareness for the Commission to be talking about the danger of these outside groups and the danger of these big organizations from outside of Oklahoma, and at the same time crafting a rule with one of those organizations. Furthermore, even the Brennan Center, which advocates for rules like this, described the concept here as tricky, and said that described the rule as the idea is novel, certainly unusual. These are all quotes from emails from the Brennan Center to people on the Commission, staff on the Commission, as well as to staff and to the chair here. We've been looking, the Brennan Center writes, Brennan Center expert writes, we've been looking hard at the constitutional limits of regulating legislative issue ads, and it'll be tricky. Right, so the idea that this is obviously constitutional, even the person who worked with the Commission staff to draft this rule thought it was at least tricky and novel and unusual. We've also been assured that it's very narrow. But here's a quote from an email that says, the challenge is to try to encompass those entities funding communications and also those low budget or no budget activities trying to do the same thing but using volunteers. This is internal communications written by Ashley Kemp, working on this rule, stating that the purpose of this rule from the beginning, now granted it has narrowed over time, but the purpose of this rule was not just to capture people spending money, it was to capture people not spending money, and it was to capture volunteers. And I think that for this commission to tell the media and tell other people that no, this is very narrow and our intent was never to do that is simply dishonest. Finally, the one thing that hasn't been discussed here yet today is the fact that the commission does not have power to do this. And this here might sound like a paraphrase from my testimony at the meeting 2 weeks ago. It says, under the Oklahoma Constitution, the Oklahoma Ethics Commission only has jurisdiction to enact and enforce rules for ethical conduct of state officers and employees, and then it quotes the Oklahoma Constitution to that effect. But that's not a quote from me. That's a quote from the Oklahoma Ethics Commission's General Counsel in an email to a person asking whether the commission had the power to regulate local officials. And the General Counsel, the legal expert for the Oklahoma Ethics Commission, assuring this person that no, the power of the Oklahoma Ethics Commission is in fact limited. It's limited by the state constitution. And while it reads like a paraphrase of what I mentioned to the, well, it is a paraphrase of what I said to the commission at the last meeting. It's a quote from their own legal expert that I think you should take seriously. What sets the United States apart is not just that we have freedom of speech, not just that we listen to lots of people in our political debates, but that we actually place limits constitutionally on the power of government in general and on the power of particular government agencies in particular. The Oklahoma Ethics Commission does not have the power to regulate in this area. That power is reserved to the legislature. Thank you.
Don Spencer from OK2A.
Thank you, Madam Chair. And Madam Chair, if I understood you correctly, if there was one of our members or associates that had sent you a message that said where you need to go that's in a derogatory fashion, that is completely inconsistent with the character of our organization, and that's completely uncalled for, and I never suggested that. And never do and never will.
No, and just to make sure nobody thinks that was an individual writing for themselves.
Okay, thank you. All right. Anyway, be as it may, our organization, this decision would affect us directly. It was almost like it was written against us. The way we are, and I am an advocate, and our group is nothing but held up by advocates. And also, like I say, anytime you make any hindrance upon our First Amendment right, it's going to directly go into effect our Second Amendment right to get back rights that should have never been taken away by the history of this state legislature. So obviously, I appreciate your support earlier. I ask you to vote no on this, and thanks very much for your time.
Sean Parnell, I believe.
That's correct. Thank you for allowing me to testify. I'm Sean Parnell. I'm with the Philanthropy Roundtable, which is a national organization that represents philanthropists who give to a wide variety of civic and charitable causes. Some of our members are from Oklahoma, and others give to charities here in Oklahoma. I want to thank the Commissioner for her comments about meeting with the C3s and learning from them about the sort of burdens that this would impose. I represent many of the donors who give to those C3s. And what I wanted to do in my hopefully very brief comments, I have submitted longer written comments that I hope you'll read, but very briefly, I just wanted to add a little bit of context to the discussion of disclosure of donors to charities. We talk about it quite often in terms of, who is George Soros giving to, who are the Koch brothers giving to. But the idea of donors having the ability to give to charitable and civic causes anonymously, or at least out of the public eye if they wish, is a value, a principle that is deeply embedded within the philanthropic community. It extends back to ancient times. Jesus spoke about it in the Sermon on the Mount when he said, do not do your charitable deeds before men. Roughly the same time, the Roman senator Seneca the Younger was talking about the importance of giving privately when you give. Islam, Judaism, Hinduism, all of these faiths have very rich traditions and injunctions favoring private charitable giving that is not disclosed to the public. And what I am afraid of is that if this rule or something along these lines is adopted, what you will wind up doing is undermining this very important principle, and you will have philanthropists that hesitate to give to charitable organizations because they will fear that their giving will somehow be revealed to the public. You will have charitable organizations hesitate to speak out on behalf of the people that they work with, that they represent, and that they speak for. And you will ultimately have the people who are most impacted by this sort of a rule be the small grassroots organizations that spring up when they see something in the legislature that they feel very strongly for or against. So I would encourage you to keep these thoughts in mind as you consider what to do. We talk about, or some people talk about citizen groups that organize and speak to the public as if that is somehow a threat to democracy. It is not a threat when citizens and citizen groups, whether new and grassroots or established and long-standing, speak to the public. It is a strength of our democracy. Thank you.
Representative Darrell Fincher.
Thank you, Madam Chair and honorable members of the commission, and thank you to the audience for coming and participating. I wish more people would come to rule makings to find out how things actually get done and give their input. We'd probably have better rules then. I think I want to make clear, I'm here as a citizen. I'm not here representing anybody right now, even though I am. These are my own personal comments that I've had. Recently, while I was in my office, or I was out of my office at meetings, the phone started ringing. I started getting messages coming in. It was citizens were calling me, advocating against a particular bill that was out there. It's like, who's doing this? It was odd since none of them were actually in my district. You know, just getting these calls, and I wasn't there to be able to talk to them and find out what's going on. And so part of what I've seen is when this bill came out, there's a whole lot of misinformation out there. First thing I heard is that if you put something on Facebook, by golly, you're going to have to report that. And you're going to have to say it was, you know, that you were advocating for it and put a disclaimer on it. And nothing could be further from the truth. And what I realized is you've heard the whole saying that the rumor's halfway around the world before the truth can put its shoes on. That's kind of where we are right now. I think we need to clear up some of the misconceptions on here. And I know that many of the organizations that are here have been really kind of writing carefully because it helps further the misconceptions. But I'd love to see the misconceptions cleared up so people can do it. I don't want to impinge on the grassroots efforts. I've had long dialogues over several days with one of my constituents about their particular concerns with this, and I fully agree with them. You know, they want to make sure that you're not going to come in and say, well, you have to apportion the cost of your internet connection because you're sending out emails. Or, you know, you decide to go down and run off some letters and you're doing 4 separate issues. How does that come in? Do I have to put a disclaimer on all of them? Part of that could be addressed by a higher threshold on that. But basically, I would like to see more understanding of what's going on. I think we need a lot more clarity about how that actually works. Thank you.
Citizen Chris Moe.
Hi, I'm a cannabis activist. I started doing this a little over a year ago. And when I started, one of the issues I had was I was afraid to get up and talk in front of people. And so I wanted to do voter registration drives. But I couldn't see myself sitting in front of a table and waiting for a bunch of people to come and talk to me. So I put out on Facebook that I would come to your house. And I rode my motorcycle around the state for months, registering people to vote, sitting on their couch and having coffee and talking to them about 788, some for it, some against it. One of the biggest things I've learned in this last year and a half of doing this is the citizens don't want to be on a list. And while that's a generic statement and I understand it doesn't quite fit with what you're saying here, the chilling effect of this rule has already caused people to withdraw. I now go to patient recommendation rallies where doctors sign their medical cannabis recommendations. When I take pictures, people immediately make sure I'm not in the picture. I don't want my boss to see I'm here. I don't want my wife to see I'm here. Whatever the case may be, they don't want their information out there. I'm always real careful about that and never cross that line. But the point here is, if I told them, oh, well, you're getting this, so I'm gonna have to put your picture out here, then they would turn around and walk away. These people would disengage, and the next movement, whatever it is, will be stopped. Now, maybe cannabis isn't a popular issue at your table today, but it may not be cannabis next time. It may be something that you support. The problem here isn't the popular speech, it's the unpopular speech. And those of us that say the things that are unpopular worry about the repercussions of our own government. And this would, in our minds, put that fear on us to the point that we would recoil and we would engage less in our government. So I would just ask that, in my opinion, this insanity stop. This doesn't need to happen. Not to mention this $500 limit is extremely low. It's lower than the other states. And I also see, while I know you guys don't all meet in the same room, I also see a connection between the suggestion put forward by Senator Allen that there be a $50,000 bond for a rally of more than 100 people at the Capitol. That costs $500 with a bondsman. So, to now have, if this was to pass, to have a rally at the Capitol, you have to be a registered indirect lobbyist. That's it. Thank you.
Thank you. AJ Ferrati.
Thank you for the time today. I appreciate it. AJ Ferrati here as a private citizen today. And I really wanted to address a couple of things that had been said at past meetings. It wasn't brought up today. But a couple of things that were brought up at past meeting was that there's already disclosure requirements to the IRS. And I just kind of wanted to touch on those as somebody who has represented clients before the IRS, particularly nonprofits who have to file Form 990s on whether they be a 501c3, which is a true charity in that sense of a term, a C4, which are generally allowed a little bit more political activity than a C3. A C3 has de minimis activity allowance, and C6s, which are trade associations, generally speaking. And one of the notes that was made is that disclosure is a requirement to the IRS, and so some of this language was written in that vein. And I wanted to highlight that the disclosure of donors is in a very narrow set of circumstances when you file your 990. Those donors are given, first of all, privately. The public disclosure of a 990 does not include your list of donors. That's given to the IRS for those specific reasons, including the fact that if you are a donor to that and you claim that on your tax return, whether you're an entity or an individual, they need to be able to go back and pair that and verify that you actually did give that contribution. So that's part of the reason why it's done that way. But more interestingly, in recent years, there's actually been a rulemaking process at the IRS to do away with Schedule B, which is the area where disclosure is allowed. So I don't think that the information that was provided related to the IRS disclosure was complete. And I just wanted to simply stand up and provide a little bit more full color around that. So if you have any questions about that in the future, please be happy to answer.
Thank you. We are now ready for ACLU's Ryan Kiesel. With apologies if I mispronounced your last name.
No, you got it just fine. Thank you.
Thank you.
And good morning, and thank you, members of the Commission, Director Kemp, members of the Legislature, and the public that's joining us today. I want to begin by saying that I believe that these rules are well-intentioned. I think that they come from a place of good faith. However, I believe that they will have unintentional consequences that will be detrimental to the democratic process in the state of Oklahoma. First, I want to just talk momentarily about the different audiences that lobbying disclosure rules and candidate campaign disclosure rules are meant to protect and empower, because I think that that's an important bifurcation here. First and foremost, in candidate-centered campaigns, because we've seen comparisons today to these rules, to the disclosure requirements for people that are either candidates themselves or an entity that's trying to weigh in on an election. In that instance, the people that we're trying to protect and empower are the voters of Oklahoma, the people that are engaging in the democratic process. We want to make sure that those individuals, when they go to vote, know who is supporting or opposing a particular candidate or ballot measure, so that it may give us some sense of what the prerogatives or predispositions of a particular candidate may be in the event that that person becomes an elected representative, or in the event that a ballot measure does pass. That is different than the lobbying disclosure rules that we're talking about today. Today we're talking about rules that are meant to empower and protect lawmakers and legislators. And they have a different sort of power and leverage that a voter in a regular election does not have. If you're a lawmaker today and someone comes to you with an indirect lobbying communication and asks you to support or oppose a particular piece of legislation, you have the power as a lawmaker to say, I'm not going to take any action as a result of this communication without you disclosing to me who's funding this indirect lobbying effort. Lawmakers have that power today. They can withhold their vote. And so that's very different. That's a very different dynamic than we are dealing with in elections. So lobbying disclosure requirements and election disclosure requirements are both important, but I think that we should have them in separate conversations because they're meant to achieve two different ends. Second, when we talk about, and I do appreciate the Commission's consideration and amendment of the rules around disclosure of nonprofit entities, that would certainly have an effect on the ACLU of Oklahoma and our donors that give to us in the state of Oklahoma, many of whom want to remain anonymous for reasons that many of you can imagine, that it's not necessarily popular to give to the ACLU of Oklahoma, or they may believe that that's the case and they don't want to be on a list. So I appreciate the Commission's consideration of amendments that account for the importance of donor anonymity to 501c3 and 501c4 organizations. But I think that the bigger problem that we're facing here is who this is ultimately going to impact. Because even in its current form, the disclosure and compliance requirements here, while they may be troublesome and burdensome to the ACLU of Oklahoma and our indirect lobbying efforts before the Oklahoma legislature, they're not going to put us out of business. I can hire a compliance officer, I can contract with outside counsel to represent us to ensure that we're complying with the ethics rules and that we're doing all of the right disclosures that we need to. But I'm thinking more of groups from maybe a small town like where I'm from, Seminole, Oklahoma. You maybe have 10 or 15 citizens who become concerned about a particular issue, and they want to lobby their legislator, and they shouldn't have to be limited to the most pedestrian lobbying techniques available. We live in a time where buying Facebook ads, not just posting something on Facebook, but buying Facebook ads or promoting a post in a targeted way. The sophisticated act of advertising and communicating isn't limited to top-tier political consultants anymore. These methods are available to everyone, and that includes patch-through phone calls, where a phone call goes into a person's house, they pick up the phone and they say, this bill is, House Bill 1234 is going to affect your rights on this issue, whether it's a Second Amendment issue or whether it's a reproductive freedom issue. If you feel strongly about this, press 1, we'll connect you to your legislator's office. Citizen lobbyists should be able to have this technology at their disposal, and it costs money. But if you have 10 to 15 people in a small community that want to engage in this type of activity, and they pick up so they may have this sophisticated lobbying tools at their disposal because it's become very easy and intuitive for them. But they pick up the Ethics Commission rules, and they're not going to have the benefit of that 10 to 15-minute PowerPoint presentation that we saw at this last meeting that helped all of us try to wrap our heads around what this rule is meant to do and what it's not meant to do, and what it's meant to capture and what it's not meant to capture. They may look at that and very well say, the risk of being out of compliance is simply too great. The cost of compliance is simply too great. And they may throw their hands up and say, we're simply not going to engage in the democratic process. we're not going to raise our collective voice to our elected representatives. And we would never know about it. That's the chilling effect that this rule will have, whether it's intended or not. And frankly, the constitutional issues, and the ACLU of Oklahoma, we are a nonprofit, nonpartisan organization dedicated to protecting civil rights and civil liberties as they exist fundamentally through our state and federal constitutions. There's been some conversation today about the First Amendment. And I do have some First Amendment concerns here, as I just mentioned, the possibility of chilling speech. But I would ask you instead to look at the 14th Amendment and its requirement of due process and notice. And it requires that the average citizen be able to know what is expected of them by their government at any given time. And if you're an average citizen and you want to engage in the democratic process, my concern is that these rules, as well-intentioned as they may be, are going to be so vague and ambiguous that the average citizen won't be able to know how to comply, and they'll simply walk away from the democratic process. I thank you for your consideration of these remarks and for the remarks of everyone here, and I would just draw everyone's attention to the diversity of concern regarding these rules. When the ACLU and the Oklahoma Council of Public Affairs stand before a governing body delivering the same appeal to the voting members of this commission, I don't think it necessarily means that we're right, but I do think that it deserves your attention. Thank you so much.
Alec Action and Amy Anderson.
Thank you so much for having me today, Commissioners, Kemp, members of the legislature. I really appreciate your attention this morning. I did offer testimony 2 weeks ago, last time we met, so I'm not going to repeat some of the points, and I thought they were made very eloquently by other groups here today. But one thing that I did want to take just a couple of minutes to elaborate on was the impression that I think has been given that this amendment would be just bringing Oklahoma laws up to kind of national standards and match what is done in other states. I know we've heard that 40 other states have some sort of indirect or grassroots lobbying provision that would regulate this sort of conduct. And by our research, and I'm not sure where you all have gotten your information and done your research, but by our research, we have noted that there are about 30 states that have a grassroots or an indirect lobbying provision. So a full 20 states do not have such a provision. And I think one material difference that in just hearing about those numbers you don't get is that in those 30 states that do, there are a couple of key differences. One, mostly those rules are much more narrowly tailored. For example, the way that indirect lobbying is defined in this amendment, I think is different than the way we see it in most states. In most states, it's an ask to contact your legislator about a bill. This doesn't require that. This is just are you trying to communicate to influence a bill before the legislature? It's a significant difference. Another thing that I think is not necessarily reflected in that 30-20 or 40-10 split, depending on how you look at it, is that in those 30 states that I'm aware of that do have indirect lobbying or grassroots lobbying statutes, very, very few of those have any sort of donor disclosure requirement. Very few. I know of 3. There might be 1 or 2 others. We were trying to scramble together to make sure and review all of these statutes in advance of this hearing. But it is very rare that you see donors to groups being disclosed, even where in option 2 you've got an earmark saying that if this is given for this purpose, even with that purpose, you don't see states taking on donor disclosure. And I think that's probably partly because it is so complex to deal with constitutionally, and it does begin to really violate First Amendment rights of speech and association and privacy. So those were primarily the issues that I wanted to bring up. The other element is that I know this rule has the $5,000 threshold to start to trigger that report that you file where you do disclose what donors have given to your organization. In most states, we see higher thresholds. $5,000 is actually a pretty low threshold when you're considering grassroots lobbying efforts. For example, Minnesota, which I know You guys have looked at some case law there, that threshold is $50,000. So, and I think the narrowly tailoring of those laws, the higher thresholds, are part of the ways that states have tried to keep these indirect and grassroots lobbying statutes from violating First Amendment rights and from chilling the speech of individuals and from getting at those small organizations that are just trying to speak up and engage with their democracy. So I thank you all for your time and appreciate your attention to this issue.
Citizen Timothy Harper.
Many of my concerns have already been addressed, but I'd like to start things out with one of my favorite quotes by St. Bernard of Clairvaux, 870 years ago. The road to hell is paved with good intentions. And I believe you all have good intentions in what you're trying to do, but what you're doing is you're planting the seed of tyranny. You're starting out small, and incrementally you can add things to these measures that you've got written down here, and before you know it, you basically silence free speech. No, there is no mechanism in this to differentiate between private donations and state-funded lobbying. So we are using taxpayer dollars against our rights in Oklahoma when we send tax money to OU Regents or Department of Public Safety, and they turn around and use our tax dollars to violate our rights in Oklahoma by lobbying the legislators here at the Capitol. And we're not disclosing that. It's a big secret. And that's one reason I oppose this, because you're not outing where the problem is. This is a solution where there is no problem. As we heard it stated, the legislator, when somebody walks in or calls him or wants to convince him to vote for or against an issue, right then and there he can ask, who is paying for this? Are you a paid lobbyist? Where's the money coming from that's got you standing right here in my office? And that's where it should start. Law enforcement also should not be lobbying our state capitol members to make the laws. Law enforcement should enforce the laws that we ask them to. They should not have a hand in determining how we want to be policed. And more we are seeing law enforcement lobbying our legislature to enact laws that they will enforce. We can probably think back about 75 to 80 years ago of a country in Europe that used this tactic to force laws upon people, because you can't have the people that are enforcing the laws making the laws. You have to have checks and balances. Thank you.
Citizen Deborah Holden Martin.
I want to thank you very much for taking up this topic. Disclosure and transparency is a very big concern for all citizens and all voters. But this issue here that we have seems overreaching, especially for people like me. I'm very scared to be here today because I don't want to be a target. And it's not an unfounded fear. I don't want to go on record with who's been targeted, but I will talk with you in private about things that have happened.
Yes, sir.
I grew up in this Capitol building.
Thank you.
My dad was elected to the legislature when I was in the 2nd grade, and was in here through college and elected official for over 40 years in different offices. And you just can't infringe on the individuals the way that I feel this does. And the $500 limit, $500 in today is nothing. I'm unable to work right now. I'm not drawing disability. My Social Security is less than $700 a month. If someone wants to help me with expenses to come to the Capitol, I'll be more than happy to take it, but it's not going to sway my opinion. And it is up to the legislature, the individual legislators, to know where they're met, who's talking to them. And when Dad would get, he was back in the days of mail, unsigned letters went in the trash. We had stacks on the desk. He was majority whip in the Senate for a long period of time. And the small stacks, I mean, there would be stacks, yes and no stacks. And whichever stack was biggest, that's how he voted. And as far, and you mentioned hearing from people that weren't in your district, I will call legislators from every district because they are enacting laws that affect this entire state. And thank you for your time, and please, just of the people, for the people, and by the people does not work if the people remain silent, and the actions you take today will silence people.
Thank you.
Joe Dorman, representing OICA.
Thank you, Commissioners. And first, I want to start off with saying thank you for your service. Through the 12 years in office I served, the Ethics Commission was very open and very fair with the questions. Even when I received my punishment, I had to pay penalties. I took them willingly because I knew I had done wrong. And even in the last experience with this job, I called the office a couple of weeks ago asking for advice on how to handle the work that we do as a nonprofit, and received great advice. So appreciate everything that you're doing to assist the citizens. And also appreciate your comments about the Tulsa World and the Daily Oklahoma. I think the last time that both papers agreed on something is when they endorsed my opponent for the last office I ran for 5 years ago. So it's not often that they do agree, sometimes they do. The issue we're discussing today is serious for the nonprofit world. I transitioned from the political world to the nonprofit side. And I have an ulcer now, having run a nonprofit, even beyond what I did at the legislative level. So I understand the stress that we go through each and every day to try and make budgets. The Oklahoma Institute for Child Advocacy was created 36 years ago as a result of the Terry D. lawsuit. If you're not familiar with the Terry D. lawsuit, this was brought forth by 7 teenage plaintiffs who were in the care of the state. The care of the state means they had agency employees who were overseeing them, who were raping and abusing them. OICA was created as a nonprofit voice outside of government to hold legislators accountable and to raise awareness with the public, to ensure that citizens knew what policies were happening in state agencies and what laws were brought forth by lawmakers of what would impact the children of Oklahoma. We're a part of a collaborative effort called the Partnership of America's Children from across the United States, where our entire mission is to raise awareness. Part of that goes into the lobbying side. We have to comply with the IRS code, tax code, to ensure that not more than 19% of our budget goes towards any type of advocacy here at the Capitol. When we walk that fine line, and we have to file that information with our 990. We have a lot of our donors, as was said before, who contribute to different facets of the organization. We will have to hire a compliance officer if something like this were to pass. And I can assure you that cost would shut our organization down. We simply cannot afford that. We're operating at just over a $400,000 budget. If I have to hire somebody full-time to come in and file reports, I'm going to have to take that money and those resources away from another part of our organization. Everything that we do raises awareness, directly or indirectly. We run the OK Foster Wishes program, which partners with the Department of Human Services to collect the lists submitted by foster kids, to distribute those to donors throughout the state. Those individuals will fulfill those wish lists and send them back. All throughout that period of time, I am writing columns, sending them to lawmakers, distributing them to newspapers throughout the state. The main mission of that is to correctly, I want to raise that awareness with lawmakers so they understand the trials and complexities of what we're going through to ensure these kids receive this benefit through DHS. So you can argue every single aspect of what we do with the Institute for Child Advocacy has some impact on encouraging lawmakers to think about the policies that they're passing and to do better for kids. And Senator Allen's bill was brought up. There are ideas that are coming forth that don't necessarily involve policies with kids, but will involve advocacy and how well we can function. If a piece of legislation like that were to pass and we had to file a $50,000 bond, I promise you we will do it, because on May 8th, we have Child Advocacy Day at the Capitol, where we ask all nonprofits that deal with kids from across the state to come to the Capitol and share their voice to ensure the lawmakers understand what the kids in Oklahoma are facing. When you look at the statistics of what the children in Oklahoma face, being #1 in adverse childhood experiences with multiple cases, with us having dead last in summer feeding programs, we are not doing okay in Oklahoma. We have to be there to be a voice for children. The unintended consequences of something like this could be devastating to OICA and many other nonprofits. So please, as you're going forward, consider what you're going to pass, consider what it will do to the nonprofits like OICA, and I can assure you, you probably could ask all 149 legislators who served last year, and we made them mad at some point because of a stance we took on a bill, but it was based on the recommendations from our fall forum, the work with our board of directors, and the input from citizens around the state. And we carried that forward here at the Capitol. We need organizations like those nonprofits that can be the voice for their constituents, and other nonprofits that either are afraid to or don't have the resources to come to the Capitol. Don't stifle that voice with an unintended consequence. I implore you to consider what you're passing and make sure that we do something for transparency and accountability, but don't harm Oklahomans with some unintended consequence.
Representing OCTA, John Frazier.
Morning. My name is John Frazier. I'm an activist, and I would be a lobbyist underneath this bill. I started my activism about 4 years ago. It was not popular at that time, so we had to go around the state, and we had to do debates, we had to do arguments, and we had to educate people on State Question 788. Now, I spent money out of my pocket. I'm retired, I'm disabled, and I'm a veteran. So I spent money out of my Social Security check for gas money and my donut every morning and my truck stop burrito every day for lunch. We went all over the state and we registered voters and we educated people on 788. So now we're coming up. Those people came to me and they said, John, we really appreciate what you're doing. And everything was coming out of my pocket. And then these little old ladies would come up to me and I say, John, I get $700 a month on Social Security, but you are helping so many people. I want to give you $10 out of my check. Now that's 2 meals that that person missed, and you want to make that person a lobbyist. No, they wouldn't be for $10, but they sure think they would be. And that's the thing, the fear that government is putting in the people. We want freedom of speech. It's not a privilege, it's a right. We have a right for freedom of speech. And I want my people to be able to say what they want to say. Thank you.
Mm-hmm. That concludes public comment, and we are ready to go to the next item on our agenda.